sixth seminar in our Health Law and Policy seminar series for the year 2011-12. We have a co-sponsor for today. We're delighted to have the co-sponsor, the Canadian Centre for Ethics in Public Affairs. And Chris Stover is going to spend a couple of minutes, 1 or 2 minutes, talking about the centre.
Thanks, Elaine. The Canadian Centre for Ethics in Public Affairs is a joint initiative of the Atlantic School of Theology and St. Mary's University, mandated to provide an arena for critical thinking on all matters that intersect with ethics. And we do that in 3 ways: through public programming, like events like this. We support research, and we also help organizations develop frameworks for dealing with ethical challenges. For more information on CCEPA, there's a table off to the side there where you can see a few of the things that we're doing and sign up if you'd like to be notified about our events. And there's also a bit of information on our upcoming event. We're currently developing a series called The Elements: Ethical Uses of Our Resources, Food, Oil, and Water. And the next talk in this series is April 3rd at St. Mary's on water with Alana Mitchell, author of Seasick, and she'll give a talk about carbon and the oceans, the considerations when you mix oil and water. So that should be quite good. If you could join us for that, that would be wonderful. We've also got some evaluation sheets on the desks in front of you. If you could fill them out, those would be great. There's also some extra ones on the side. It helps us develop future programs and tailor them to your needs. I'd also like to welcome our virtual audience today. We have a live stream audience, and you can participate in the evaluation process as well. There's a link on the screen, a feedback link, and that would be great. So thank you again all for coming, and I hope this presentation is of value to you.
Now, it's my great pleasure to introduce our speaker for today, Joan Gilmour. Joan comes to us from Osgoode Hall Law School, which is part of York University in Toronto. She did her LLB at Toronto and her JSM, which is a Master's in the Science of Law, I had to look it up, at Stanford, as well as her JSD. She is director of the law school's master's program specializing in health law. So this is a part-time program for students at the master's level, usually people in practice, I believe. She teaches a great number of courses, including at the graduate level, professional governance and legal frameworks of the Canadian healthcare system. She was formerly director of the Osgoode Institute for Feminist Legal Studies. She has a strong focus in her research on the laws affecting the withdrawal of life-sustaining treatment. She's got an excellent chapter in particular, the second edition of Canadian Health Law and Policy on the topic of children in health law. Joan produced an excellent report on patient safety, medical error, and tort law. And Joan, we don't often have people who we ask to, who have spoken before in our series, but we ask them to come again. But Joan spoke a number of years ago. Some of you were likely here, spoke on complementary and alternative medicines and the law. A decision came out a couple of years ago called AC versus Manitoba, and many of us in the area of health law have struggled with this decision and with trying to understand it. For me, every time I'm going to lecture on it, I go running to my colleagues and say, okay, so is this what you understand of it? And we sort it through once again. And it was the idea of my colleague Michael Hadskis to invite Joan to come this year to set us all straight on the meaning of AC and more generally the topic of ending life-sustaining treatment for children, decision-making when health providers and parents or patients disagree. Please join me in welcoming Joan.
Thank you very much, Elaine, and I want to thank the organizers for inviting me here today. These are troubling issues, and I really appreciate the opportunity to keep working through them with you, and I hope that you'll be able to provide me with your input and thoughts at the end of my remarks. Making decisions about life-sustaining treatment for children when parents or the patient themselves disagree with the healthcare providers is a really difficult area. But then, to take on discussing both decision-making by adolescents, where it is argued that the treatment will work and will save the adolescent's life, but the teenager refuses, as well as cases where it is argued that the treatment can't work or won't benefit the patient, but the parents or the substitute decision makers insist that the treatment be provided or continued, that's a truly daunting task to take on both of those. Except that when you think about it, those are both aspects of the one larger issue. How should decision-making about life-sustaining treatment proceed? And more specifically, who should decide, right? Who has power and authority, and what limits are they subject to? So I'm going to begin with talking about the case that Elaine had referred to, the Supreme Court of Canada's decision in AC, which is a case dealing with an adolescent who wanted to refuse life-sustaining treatment. And I then will move on to the other aspect. What about when patients or parents want to continue with treatment that healthcare providers no longer feel would be of benefit? Okay. So I'll start with AC. In AC, there was a situation where a young teenager of 14 years and 10 months old was admitted to hospital suffering from gastrointestinal bleeding that was caused by Crohn's disease. And her physicians had concluded that she needed blood transfusions in order to prevent serious risk to her health and perhaps to her life. She was a devout member of the Jehovah's Witness faith, and both she and her parents strongly opposed transfusion on religious grounds. And there had been a brief psychiatric assessment. There were 3 psychiatrists. This took place at the hospital the night after her admission, and they had concluded that she understood why a transfusion was needed, and she understood the consequences of refusing that. She did refuse it. She was supported by her parents in that decision. And on being alerted to the situation, the Manitoba Director of Child and Family Services apprehended her as a child in need of protection and sought a court order authorizing treatment, so blood transfusions, as being medically needed. And they sought that under that province's child welfare legislation, the Child and Family Services Act. And the lower court authorized the blood transfusions, and that was affirmed by the Manitoba Court of Appeal. So AC and her parents appealed that further to the Supreme Court of Canada. And you need to understand that under the relevant statute in Manitoba, it provides that if a child is 16 years or over, then the court cannot order treatment without consent if the minor is decisionally capable, able to make those decisions for herself. But AC wasn't 16 years or over. She was 14 years and 10 months. And so the statute goes on to provide that when the child is under 16 and the treatment is medically recommended and the parents won't consent and the child's not consenting, the court holds a hearing into the matter and it can authorize any treatment for that child that it concludes is in the child's best interests. Right? So we contrast that then, the statutory provisions, with what the common law would provide. And at common law, if AC, even though she's 14 years and 10 months, was what's called decisionally capable, then she could decide for herself whether to consent to or refuse that treatment. Okay? And so that would mean if AC could understand what was involved in the treatment and the alternatives, including no treatment, and appreciate the consequences of accepting that treatment or refusing it, then she would be considered decisionally capable at common law, and she would be able to make that decision. Okay? So faced with this difficulty, one of the things that the court, of course, had to recognize was the tension that existed in the state obligations. And you can see that in the lower court decisions as well, because the state has an obligation to protect individuals' right to autonomy and bodily integrity. And it also has an obligation to nurture a child's potential for autonomy, right? However, the state has an obligation to protect the rights of vulnerable populations, and that includes children. And so they have a right to life and health and a right to protection. Okay? And it is then recognized as a basic tenet of our legal system to protect children from harm. Okay? So there's a real tension and I think an inclination in terms of the values the law will advance to ensure that the protection of life and health of the child is front and center. So what then does the Supreme Court do to resolve this tension in AC? Well, 6 of the 7 judges who heard this appeal concurred in the result, though there are some differences in the analytical route that they took. And they held that where there is a mature minor, even though under 16, then his or her decisions about treatment have to be taken into account regardless of her age. What that meant in practice was that it was a philosophical victory for AC, but since the Supreme Court of Canada went on to uphold the lower court's decision authorizing treatment, authorizing the transfusion, in practical terms, it was a loss for AC, though actually the transfusion was long past at that point. When the lower court decision came down, the transfusion took place, and AC continued on. Right? The reason that the transfusion was authorized, though, by the Supreme Court of Canada was because the majority determined that there actually had never been any real determination of whether or not AC, the 16-year-old, was decisionally capable. So the court had simply gone ahead on the basis that it was assumed that she was decisionally capable. But as the Supreme Court of Canada pointed out, there'd never actually been a determination that she met that test. And then there was one of the 7 judges who dissented and said, indeed, she was decisionally capable as that term is understood in law, and therefore, if she refused treatment, that was an end of it. Her refusal should be honored. Okay? Now, it's interesting to look at how the judges took the decision of younger minors into account, right? Because the court here does not limit its analysis to just the 2 possibilities. In other words, you can find the minor capable, and so she would prevail, and the result of that would be that death would follow. Or you find the minor incapable and just ignore her views. So the Supreme Court didn't look at it as that kind of an either-or choice, and it took account of other values that are engaged in addition to respect for autonomy. Okay? 4 of the 6 judges noted that mostly when you're looking at healthcare decisions, the minor's life or health is not gravely endangered by having a particular treatment or not. And so generally, doctors can rely on the instructions of a young person who seems to demonstrate sufficient maturity to direct the course of her treatment. Okay? That's most cases. But as Madam Justice Abella, writing for the majority, points out here, things are different in the context of child protection proceedings. Why is that? Because in that context, the Child Protective Services are involved and they have concluded on medical advice that medical treatment is necessary to protect the life or the health of the child, and either the child or the child's parents have refused to consent to it. So that is a very limited class of cases. When it does arise, though, the consequences of refusing treatment will be so grave, the stakes are so high, then, as Madam Justice Abella says, the ineffability inherent in the concept of maturity justifies the state retaining an overarching power to determine whether allowing the child to exercise his or her autonomy in a particular situation actually accords with her best interests. In other words, what she's saying is, first, it's hard to figure out what maturity is, and second, it's really hard to figure out whether this adolescent is mature enough in these circumstances. So it's a case-dependent decision. And the degree of scrutiny that will be applied is inevitably going to be most intense in cases where a treatment decision is likely to seriously endanger a child's life or health. So the majority concludes that effect can and should be given to a younger minor's decisions about treatment if she is sufficiently mature and independent. But it's saying you do that in these child protection proceedings through the vehicle of the best interest test. In other words, if a minor is mature enough, then it will be in her best interests to respect her decision about whether to consent to treatment. So Madam Justice Abella says, the more a court is satisfied that a child is capable of making a mature, independent decision on his or her own behalf, then the greater the weight that will be given to his or her views when a court is exercising its discretion under the statute about deciding about her best interests. And she goes on to say that there's going to be cases where a court is going to be so convinced of a child's maturity that the principles of welfare, doing what's in a child's best interests, and autonomy, following the child's direction, will essentially collapse together, and the child's wishes will become the controlling factor. So she concludes then, if the court is persuaded the necessary level of maturity exists, it seems to me necessarily to follow the adolescent's views ought to be respected. So what the judgment does by taking this approach is to avoid an absolute and seemingly arbitrary age limit, right? If you're over 16, you get to decide. If you're under 16, you don't get to decide at all. And leaves for the adolescent then the opportunity to demonstrate sufficient maturity once she's in the care of the state. So the best interest test is understood as an evolutionary compendium, she says, of the considerations that would give increased weight or increased strength as there's increased maturity. Okay? So she affirms the constitutionality of this statutory best interest test, but she does it by adding this gloss to its interpretation. And so she achieves a reading then of the Manitoba legislation that makes it consistent with our constitutional guarantees of respect for life, liberty, and security of the person, and also the guarantee of freedom of religion. Okay? And it's in doing that, that is a well-known and long-standing general legal principle that if you can, you interpret legislation in a way that accords with constitutional guarantees, rather than just striking it down as unconstitutional. So as I say, there were four of the seven judges who aligned themselves with that judgment. Madam Justice McLaughlin wrote the concurring judgment. She agreed in the result, but took a somewhat different analytical approach. She actually concluded that the statutory scheme in Manitoba was complete in and of itself. It effectively displaced the common law mature minor doctrine. And she points out that the statute directs the court to consider and to weigh all the relevant circumstances when deciding best interests. That includes the child's needs, mental and emotional maturity, and also the child's preferences. But she says, because there are heightened concerns with younger adolescents about both their maturity and also their vulnerability to coercion, right? And those factors, as she points out, can be very subtle, right? Not blatant. But because there is that vulnerability and because it's not very practicable, particularly in these types of cases where you may not have a lot of time to make a decision, she says that vesting treatment authority and using that cutoff age limit of 16 allowing for taking into account the adolescent's preferences is in fact justified. So for her then, the younger adolescent's treatment preferences are a factor, but it doesn't have the presumptive weight that it would have in Abella's judgment for those adolescents who can demonstrate the necessary maturity. It's also interesting in her judgment because she picks up on a theme that is present in Abella's majority judgment but not emphasized as much, and that is that she really is looking at two different types or two different meanings of capacity. And the first would be much more of a cognitive test, and that's the one we're familiar with from many statutes that set out what it means to have decisional capacity. And that would be one that focuses on whether the individual can understand the treatment that's proposed and the alternatives, and whether they can appreciate the consequences of a decision to have the treatment or not. The second and broader understanding of capacity, and the one that she finds is properly taken into account with respect to younger adolescents, is one that is a broader understanding of capacity and that pays more explicit attention to ethical and emotional as well as cognitive factors. And I think Madam Justice Abella does that, though not as explicitly as well. And as I say, in affirming this assessment, what McLaughlin notes is that this was necessary to save AC's life. And she points out that capacity in this narrow intellectual sense, the one that's applied to those over 16, she says, does not capture the constitutionally valid thrust of the provisions that pertain to children under 16. The decision to assume capacity in the narrow sense, but conclude treatment should be ordered on the basis of other factors, was therefore not an error. Okay? So she's looking at, I think, a broader scope for what capacity means as being appropriate and legitimate for those who are less than 16. So one way of looking at this decision is that it is quite specific to Manitoba legislation. I actually think it has considerably broader implications than that. And so with or without legislation, and many provinces have legislation similar to Manitoba's, but even if it didn't, I think that the approach that the court takes is significant and provides guidance in how these decisions should be undertaken in future. And so the court goes on to talk about what factors may be helpful in determining whether or not someone possesses sufficient maturity, a younger adolescent, to make their own treatment decisions. And there's a whole list of those. They're set out at paragraph 96 in the judgment. They have to do with the nature of the treatment and its utility. They have to do with the legal test we're familiar with for capacity in terms of an intellectual capacity to understand and appreciate consequences. Are the adolescent's views stable, and so on and so on. And so that's the list. There are some questions, though, that remain open. One of those is, I think, pointed out by Madam Justice McLaughlin herself, and that is whether a judge would ever, under a legislative scheme like the one that we see in AC, actually decline to order medical treatment for a child who is under 16 when the result would be probable death. Right? So what if you were in a situation, which you could well have been in AC, if Madam Justice Abella had not concluded, nobody had ever decided if she was mature in that sense or independent in that sense. But would a judge actually say for a child who's 14, your decision stands? Right? And similarly, the judgment also, I think, leaves open where this line between situations where autonomy prevails and where forced treatment should be ordered. Where does that get drawn in particular cases? Although the judges certainly indicate in the majority that the more dangerous the situation is from the perspective of the child's life and security of the person, then the more compelling the case has to be that the child is fully mature and independent enough to make up her own mind. Okay? And one other problem that I have with the reasoning is with the majority judgment of Madam Justice Abella, who talks about the importance of recognizing a mature minor's decision and essentially the distinction between autonomy and welfare principle collapsing when you have a minor who is mature, because it is, by definition, in their best interest to follow their own decision, right? To give effect to their autonomous choice. The problem is, as I see it, is that we actually don't talk about adults' decisions in that way, so that we will often say, well, it's not in this adult's best interest to decide, say, to refuse a blood transfusion, right? The consequence is going to be she's going to lose her life or seriously impair her health. Not in her best interest. But because she's an adult, she gets to make an autonomous decision. So we tend not to collapse those two when it comes to adults. We recognize that there's a difference. But here in this context, Madam Justice Abella talks about the two of those collapsing into one. Okay? And so the two, I think one way out of that logical difficulty is if we start understanding the second part of the legal test for capacity differently. In other words, that talks about understanding and appreciating the consequences of one's decision about treatment. If you feed more into the concept of appreciating the consequences of the decision, if you feed in those sorts of considerations, you can still stay with the two-part cognitively focused test for capacity. We haven't done that in our jurisprudence so far, and it's not clear to me that our courts are going to do that, but it's a thought in terms of one way to respond. Okay? That in itself would be enough not only for one talk, but I could teach a whole course on this, so you won't get rid of me soon. I just stay for the rest of the term. But I also wanted to talk about a second aspect of this, and that is what is sometimes called futile treatment, although that itself is a very contentious term. So as we've seen in this area over the last several decades, looking at the law about when life-sustaining treatment should and should not be continued, the question arose most often in situations where it was actually patients or their substitute decision makers who wanted to refuse or to discontinue treatment, right? And that's what AC was about. She wanted to refuse treatment of blood transfusion. And so mostly we were looking at what the limits were on patients or their substitute decision makers about ending treatment. Okay? And there we have moved to a consensus that is now backed by explicit law that patients or their substitute decision makers can decide about refusing treatment. And we moved then from an earlier model of medicalized decision-making by physicians to decision-making by competent patients or by their substitute decision makers. But when the question changes as to whether life support should be withdrawn at the instance of treating physicians over the objections of the patient's family, or whether in fact the treatment has to be continued as the family wants, then I don't think that there is a consensus about the appropriate decision-making model at all when physicians and family disagree. And I think that this issue is especially difficult when the patient is a child, because we generally expect children to have their whole lives ahead of them. Okay? So I'm going to talk about that for the remainder of the time that I have today. Certainly most cases like this never go to court. Most often, parents and the treating healthcare providers can come to some agreement about the child's care and how it will proceed. And that can happen over time. They may not have agreed initially, but they can come to an agreement. There are some cases, though, that do go to court. And most recently, I'm thinking, for instance, of the case of baby Isaiah May out in Alberta, and more recently, baby Joseph Marachli in Ontario. Especially as medicine's ability to sustain life continues to increase in situations where, very recently, that would have been impossible. There are going to be more and more cases where the question of whether medicine should do more or continue to do more have to be answered, and also who gets to make that decision. These can be really agonizing cases for the family. They can also be extremely distressing for the healthcare providers who are involved. And so I think it's important to reflect on the principles that we do have to guide decision making, to understand where the gaps remain, and to think about how we ought to be going forward. And so I just have some reflections on that. So one thing that is clear, and it's a pretty fundamental principle, where the patient is decisionally incapable and where there are no prior instructions or directions that have to be followed, as would be the case with young children, they're too young to make up their own minds, then decisions about treatment have to be made in the best interests of the patient. Okay? What that means in practice, though, can be far from clear. The difficulty, of course, is that people have very different views of what's in another's best interests, right? Or they may disagree about the patient's condition, or they may disagree about what treatment could do for the patient, or what the goals of treatment should be. And finally, it can be very difficult to predict accurately what the likely effects of the treatment are. Now, in some jurisdictions, there is legislation that gives some content to this term best interests. So in Ontario, which is my home jurisdiction, there is a statute called the Healthcare Consent Act. And it provides for a number of factors to be taken into account in deciding what an incapable person's best interests are. So the substitute decision maker is told you have to take into consideration, where there aren't any prior capable wishes, what the values and beliefs the person knows that the incapable person held when they were capable. Not going to apply with babies. You have to take into account any wishes that are expressed by the incapable person about treatment, even if they're not capable. You have to take into account whether the treatment is likely to improve the person's condition or well-being, whether it's likely to prevent it from deteriorating or reduce the extent at which it's going to deteriorate, whether the person's condition is going to remain the same or get worse or get better without the treatment, and whether the benefit that the person is likely or is expected to obtain outweighs the risk of harm, and whether there's a less restrictive or less intrusive option. Okay? Those are statutory factors. At common law, where you may not have similarly worked out statutory guidance, similar factors inform courts' consideration of how you determine best interests when you're thinking about treatment. There's an Alberta decision, Swice and Alberta Health Services, and this involved an older patient, 70 years old, and the family were resisting and seeking an injunction to have a DNR, a do not resuscitate order, removed from his chart. And so when the court there talked about how you determine a patient's best interests, it talked about similar factors, with the addition of one that we don't see in Ontario, that being what is just and equitable in the circumstances. Most of the factors then are very focused on the individual. That one allows for some broader focus as well. But one of the things that you notice when looking at this guidance about how to determine somebody's best interest is that there can easily be conflict among those factors. So best interests is not a self-executing concept, right? And you may have a conflict between, say, the person's values and beliefs, if you're talking about an adult that they may have held well capable, and the medical opinion about treatment and what would be in their, for the good of their health. Okay? A second principle is that there's no legal duty to perform or provide treatment that the doctor reasonably believes to be medically futile, that is, treatment that offers no reasonable prospect of therapeutic benefit to the patient. Aha, you say, well, there's an answer. Well, no. Okay? That underlying justification rests in part on the reasoning that although patients and substitute decision makers have the right to consent to or refuse treatment that is offered, they do not have the right to demand treatment that their healthcare provider considers inappropriate or even positively harmful. And in fact, you will find similar statements in joint statements that are put out by the Canadian Medical Association, Canadian Nurses Association, healthcare organizations, et cetera, et cetera. The statement that futile treatment need not be provided seems an obvious truism. But applying this principle can be even more contentious than disagreements about what best interests are, right? Defining or calling a treatment futile is an attempt to construct and not just describe a state of affairs. Understandings of what futile means differ widely, and arguments for physician determination of futility rest on some unproven assumptions about unanimity or consensus, at least among physicians. First, about what the goals of treatment are, and second, unanimity about the likelihood of achieving those goals. And although there are not many studies on this issue, healthcare workers who are questioned about their projected decision-making in different scenarios have responded with very different treatment choices. There is apparently, from limited study, less disagreement among those who work in critical care units, but among healthcare providers, there's not that necessary unanimity. And it is also a departure from the model of shared decision-making in healthcare that assumes that patients or their substitute decision makers can make reasonable choices when they are provided with good information. Okay? So there's not necessarily unanimity among the healthcare providers. However, we can't necessarily glorify substitute decision makers' choices either. Again, limited studies, both are mostly American, but certainly there are some that have been done that say, when you check back with patients afterward, do they think the substitute decision maker got it right in terms of what they would have decided? Not so much, right? So they aren't necessarily correct either in terms of, is this what the person would have wanted? Okay? Now, there have been several Canadian cases now where families of patients have challenged physicians' decisions to enter a DNR order or to withdraw or to not undertake other life-sustaining treatment. One thing to note, most of those cases, almost unanimously by the time they get up to an appellate level, have not been framed as being about resource allocation. Okay? So you will see that perhaps mentioned in terms of how the claim was initially framed, but most of those cases are focused on the individual patient and what should happen for that individual patient without overtly or expressly taking resource allocation issues into account. Most of the cases also involve older patients, not children. There is, I think, a conflict in the cases, and it's unclear in the law right now who has the right to enter a do not resuscitate order or who has the right to have the final say when the doctors disagree with families and want to end life-sustaining treatment as not being of benefit to the patient any longer. Requiring doctors and the healthcare team to continue treating against their better interests, against their better judgment, can cause considerable moral distress because for them, they see themselves as being required then to harm the patient. There's a Manitoba case, Golubchuk, where the physicians who were involved in the patient's care, when it was ordered that the DNR order be taken off the chart in response to the family's application to court, the physicians involved in the patient's care resigned from the hospital staff. And they said they did so because they would not do what they considered to be harming the patient. They saw that as going against the primary medical principle of doing no harm. In Ontario, there's another case, Rasuli, that is going ahead. It also involves an older adult, not a child, and the Supreme Court of Canada very recently granted leave to appeal. It again is a situation where the physicians concluded that the patient was in a persistent vegetative state and that there was no benefit to the patient in continuing life-sustaining treatment. And the patient's family, patient's wife in particular, who was herself a physician in Iran before coming to Canada, wanted everything to be done and disagreed with the physician's assessment both of his physical condition and the prospects for him, as well as furthering their own ability to adhere to the precepts of their religion. Okay. And that case, as I say, will go to the Supreme Court of Canada. It is a very difficult area and one where we could certainly do with guidance from a higher court. In Rasooli, what the physicians are trying to argue is that there is essentially an area where physicians have discretion that somehow is outside of and prior to the types of things that you need patient or family consent to. That there is an area that is apart from that, and that physicians have decision-making authority within that prior area. And we don't have a final decision, certainly from the Supreme Court of Canada. I'm not sure they will accept the party's invitation to go that far and decide one way or the other on it. But I wanted to spend just the last bit of my remarks talking about the cases where this has come up with children. As I say, most of the cases involve adults. There are a few Ontario decisions that I am aware of that involve babies. The first of those is a case called EJG. The attending physicians had applied to the Consent and Capacity Board, which is a tribunal in Ontario where disputes are taken when physicians are of the view that the substitute decision maker is not making a determination in the best interests of the patient. Okay? So the parents of the baby had very much wanted treatment to continue for their child, and the physicians had concluded that it was not only of no benefit to aggressively sustain his life, but actually was doing him positive harm. The patient was 8 months old. He had suffered significant oxygen deprivation in the hours before his birth and had been in a persistent vegetative state since birth. His underlying condition gave rise to numerous sequelae, including quadriplegia, brainstem dysfunction, recurrent respiratory arrest, chronic lung disease, and other infections and injuries. EJG, it was anticipated, would spend most of his life in hospital. He would always require positive pressure ventilation and a feeding tube on an ongoing basis. And so the physicians in the pediatric critical care unit proposed a treatment that involved weaning him off the ventilator. If he could breathe on his own, then he might go home with his parents, and if not, he would be allowed to die without further attempts to keep him alive, although providing comfort care. And if he were able to return home, it was proposed that there would be no further attempts to save his life, even in the event of respiratory failure. And the physicians proposed that treatment plan on the basis that ongoing ventilation conferred no medical benefit on EJG and was therefore futile. And the physicians believed that he was suffering, even if he couldn't feel pain or discomfort, and concluded that given his condition and his prognosis, continued life was not in his best interests. His parents distrusted medical opinion. They were steadfast in their belief that God's healing powers would prevail and that one day medical science would be able to cure their son. The application to the board was for a determination about whether the parents were making treatment decisions in his best interests, and the board found that the parents had made their decision based on their own belief in God, but had not considered their son's day-to-day condition or well-being, or the likelihood that he was going to have to endure invasive treatments and further medical complications resulting from his brain injury. And they also pointed out that the SDMs, the parents, had to balance a number of factors that would include benefits versus risks of treatments. The board held that the risk of harm, even death, was not outweighed by the benefits of the treatment that the parents wanted that involved constant invasions. And so EJG's well-being, and the board said that included considerations of dignity, required that he be treated in accordance with the treatment plan the doctors had proposed. And so the board ordered the parents to consent to that. There has to be consent to treatment, or be replaced as his substitute decision makers. There was an appeal of that board decision, and it was confirmed by the court on appeal. The other case I want to speak about briefly is that of Joseph Mirachli, and not to speak about the details of the decision, but to also use it to talk about how what courts decide is only one piece of the landscape. Joseph Mirachli was a baby who had a genetic condition that meant that his life was going to end in the near future. He had had his parents had had a baby before this who was had the same condition and had also died very young. They had been able to take her home. Doctors had provided a tracheotomy, and they'd been able to take her home, and she had died at home with them. That's what they wanted to do for their son. Doctors, though, were of the view now that they knew more about what Joseph in particular was going through if there was a tracheotomy and he went home. And they were of the view that he ought to be in the hospital and remain in the hospital. They went to the Consent and Capacity Board first for determination about whether the parents were making decisions in their child's best interests. The Consent and Capacity Board upheld the doctors. That was appealed further to court, and the court upheld the Consent and Capacity Board's decision. In other words, upheld the doctor's decision. The next steps were that the parents decided that they were not going to accept that decision, and assisted by patients' rights and right to life groups in the United States, they were able to locate a hospital in the United States that was prepared to perform a tracheotomy on baby Joseph so that this would support their plan to have him come home with them and die at home. And so the judicial decision was not the end because what happened then was the parents had their child taken to the United States. That was performed, and their son passed away some months later after this was performed. So they're difficult cases, but law, as you can see, is certainly a very blunt instrument. And it is far better, if possible, to work the matter out to an agreed resolution outside the court. And in doing that, communication is key. And in most cases, that's what happens, and that's what can be achieved. But in the rare cases where you can't, then in my view, it is appropriate, and courts and tribunals do have a role in resolving these matters. There are some American jurisdictions that have tried to legislate courts out of these cases, at least on a substantive basis, and have put in place legislation that allows physicians to withdraw treatment considered inappropriate. And I don't think that's a route that we should go. That said, I am keenly conscious of the fact that I'm a lawyer. And you know the saying that if you're a hammer, everything looks like a nail. And so I'm asking myself the extent to which it looks to me like courts and tribunals are the way we should go, because I'm a hammer. And because I think courts and tribunals are generally a good and useful arbiter and decision maker. And so I would be very interested in hearing your thoughts on that. Thank you very much. So the question was what my experience is about confrontation between medical staff and the legal community with respect to issues like this. And mostly my experience is it doesn't come up. These cases seldom go to legal consultation, let alone to court. So it tends to be infrequent, and there tend to be processes within the hospital that can be accessed first, for instance, consultation with a hospital ethicist or an ethics committee, talking things out with members of the treatment team as well as the family, parents here because I'm focusing on children. So very few cases go to court. And then the experience with confrontation between medical staff and the legal community and the family as well is that, unlike most of law, there is an ability to have these decisions heard, at least in the first instance, quite quickly, which is not characteristic of most of the legal system. That said, and in fact in Ontario, the Consent and Capacity Board, which is the tribunal that would hear these cases in the first place, is required under the statute to work within quite tight timelines. So you think that that might provide a usefully timely answer. But the difficulty with that as well is that then there are appeals built in, which one would want to ensure justice, but at the same time, it also brings you to the reality, and I didn't have time to talk about it, but the reality is in many of these cases that if you are waiting for a judicial decision, you are effectively deciding in favor of those who are opposing removing life-sustaining treatment. Because the reality is that by the time the legal proceedings are concluded, the person will have passed away already. So if the family is resisting having, say, life-sustaining treatment withdrawn, essentially as the patient is maintained, then they're suffering from a serious underlying condition. And so many will have passed away and the issue itself becomes moot. The case that I referred you to, Rassouli, which the Supreme Court of Canada has granted leave, is not that case on the facts. He is being maintained on life support at Sunnybrook Hospital in Toronto, and the case will go before the court. So this question is from a physician who has the experience of having to negotiate withdrawal of treatment, if I'm phrasing this correctly.
Non-initiation as
okay.
well.
So I was going to say cessation. Okay, cessation of treatment, but more often not offering treatment in the first place, and a concern in teaching medical students who are working in the department about one's obligations or how to do that, because the medical students seem to be of the view that there is somehow a legal obligation to at least offer the treatment. And then you end up in the situation of, if you offer it, what if the family says yes? And do you then have to challenge, even to the extent of going to court, their decision to say, hey, yeah, let's have that treatment, right? Do whatever you can. Okay. So a couple of things. How did all that happen in the first place? And I've been thinking and writing about this for a long time, and I have a little bit of an idiosyncratic view of this. I actually think it started with conventions that developed with respect to, I'm walking and I said I wouldn't wander from the microphone. So I think it developed where we have conventions with respect to CPR, conventions with respect to cardiopulmonary resuscitation. So we're used to saying and thinking, we have to consent to treatment, right? And if we don't consent to treatment, the treatment can't be provided. The convention that developed, I think, with respect to CPR was actually the opposite. Look, we can do it, so we're going to do it. And we simply will assume that, of course, the patient would consent and provide it. And so it became then the exception that one would refuse consent to CPR. So I think that there are some historical factors there. I'm not a medical historian, but I do think that development of our understanding of consent to and refusal of treatment has affected where we are today. And I also think that this Rassouli decision, depending what the Supreme Court of Canada has to say on the matter, has the potential to emphasize a distinction between ceasing or withdrawing life-sustaining treatment and withholding it in the first place that I don't think exists in law. But I think depending what the Supreme Court of Canada says, at least on the basis of the Court of Appeal decision right now, that physicians may regard it as easier to not start the treatment than it will be to cease or withdraw the treatment. And I think that would be unfortunate. if there is a situation where the physician reasonably believes that the treatment could do some good and things haven't been, the patient's condition hasn't stabilized yet, so you don't know, you would want them to feel free to try that and not think of how difficult it's going to be to end it down the road should that be appropriate and should there be consent to it. So I sympathize with I sympathize with the dilemma that you're in, and I don't think in law that there actually is such a distinction between a decision to withhold treatment in the first place and a decision to withdraw or cease it later. But I also know that that can feel like a very different thing. Right? And so the question is that healthcare providers have an obligation to obtain informed consent to treatment. If the healthcare provider has determined or is of the view that the treatment is futile, won't do any good, and therefore does not have to be offered, does that in effect remove the patient's ability to give informed consent? Because part of informed consent is to tell the patient about the treatment and what it will do and the material risks, but also the alternatives. Okay? I think it's a really good question, and it really goes to the heart of what the doctors are trying to argue in Rassouli, which is that there is this area of clinical decision-making that is outside this requirement of obtaining informed consent. So if you think about it, for instance, a patient presents and in the doctor's view needs an appendectomy for whatever, presumably for a condition affecting the appendix. The patient can't then demand, and by the way, I'd like you to amputate my arm, right? So patients don't have that right to demand any and every treatment that they might like. But what the Rassouli court does with respect to life-sustaining treatment is to say, even where physicians are of the view that the continued life support will not be of benefit, because what they then proposed was to withdraw life support and begin a course of palliative treatment, right? That would certainly require consent from the patient's family. And therefore, you do have to put this before the patient's family as the substitute decision makers. In other words, there's a treatment package here, and the package is not just, for instance, starting palliative care. The package also includes what you have to do to get to palliative care, which is withdraw life-sustaining treatment. So the Court of Appeal analyzed it as a treatment package, and one still needs consent. It also, though, expressed no final opinion, but considerable hesitation about whether doctors actually had to offer treatment they considered ineffective, not of benefit, to a particular patient. We don't have a final answer from the courts on that. I think in the end there's going to have to be a final determination about who actually has the decision-making authority with respect to those different types of decisions. So it will be partly about what you decide, but it's going to be a lot about who gets to decide. And it's going to be really interesting when the Supreme Court actually, really interesting with one caveat. So I think this will be a very interesting Supreme Court of Canada decision in Rassouli, unless they simply decide to take the less contentious way out, which is simply to say that there's a statute in Ontario. The statute says you have to go to the Consent and Capacity Board first. The doctors did not, because they're arguing there is this area that is not subject to consent and the tribunal's jurisdiction. And if the court decides to, in my view, it could issue a very narrow decision that is just focused on the provisions of that statute and say you had to go to the Consent and Capacity Board. I hope it doesn't, because these cases come up not often, but they come up in different provinces that have different legal frameworks governing these decisions. They don't all have, or even most have, consent and capacity boards, and I think it would be useful to have a decision that has something to say to guide how these decisions are made across Canada. Okay, so I'm going to try to get the essence, but I can't repeat the whole. But one of the suggestions made is that work outside law and outside medicine per se, social scientists have much to contribute. And speaking of a study that has been done already, bringing together groups of those who are involved, stakeholders, in terms of what they believe appropriate considerations are to take into account, and that there is a possibility then, or is there a possibility, to make that useful to law, to have these types of broader focus groups that could perhaps not only talk about what, not only get a sense of what their views are, but also perhaps be able to produce some kind of a consensus statement about what should be. Okay.
Of things that come up in these groups. And I think maybe the longitudinal study of what happens to these people like that 14-year-old who was forced into something.
And
okay. Actually following up a 10-year study of what they think about their 20
So in certain circumstances, and also what about a longitudinal study that follows up and finds out where what people's views are as time goes on. So I think that's a really interesting possibility, but and in fact, when you look at the decision in AC, the 16-year-old and the 14-year-old and could she make her own decisions, the whole first part of the judgment consists of the court looking at social science work that's been done about adolescence and what it means to become more mature and to be able to be independent and so on. So courts do call on that kind of social science evidence, and they do it more or less successfully. They are not social scientists. Sometimes my social scientist colleagues at York talk about the things lawyers do as practicing social science without a license. And so that's a problem also in some of the things that we tend to bring into. But I think that it can be very informative. The problem with it becoming a consensus statement is that when it comes down to the court cases, they focus on individuals. Right? And so it may be that the consensus is right now that if you need a blood transfusion, you'll get a blood transfusion that can save your life or prevent serious harm to health. But we still recognize that for adults anyway, even if it's for reasons that most of us do not accept, they can turn down the blood transfusion. They can refuse it. So you have to, think about that, moving from the broader society to the individual and the extent to which the individual then must be governed in their decisions about healthcare by the collectivity. And healthcare in particular is one of those areas where we really guard our autonomy and self-determination very jealously. So I'm not sure, I agree with you, that's a useful way to come up with more stakeholders having input, particularly because these are not just medical issues. And when I think about stakeholders, though, I think about all of us, right? Whether it's affecting us right now or not, either ourselves as individuals or family members or close friends are going to be affected by this. And if not us right now, maybe as we age. So all of us then have an interest in what guidelines we come up with. And as I say, courts in these cases, they don't talk about resource allocation, but that's going to have to come into it at some level of decision making as well. And it may not be in these individual court cases, nor may it be appropriate in these individual court cases, but at some level we're going to have to figure this out. So the question is whether in a case like ACs, suppose the treatment involves ongoing administration or different bouts of administration as chemotherapy does, and do courts, and a patient who's actively refusing that treatment, and do courts factor in the fact that the patient is actively refusing it and one is actually involved in having to administer the treatment under those types of circumstances? Does that fairly represent? And yes, they do. And I can give you an example of, it's actually a Newfoundland decision that involved a 15-year-old boy who had cancer, was a member of Jehovah's Witness faith. He wanted to refuse the blood transfusions that were associated with chemotherapy. And interestingly, in that case, the treating physicians said, because so much of this kind of treatment is dependent on his buy-in, if you will, his cooperation with it, we actually can't say it's in his best interest to have chemotherapy if he is resisting. And the court concluded two things. One, he was a mature minor, in part matured by his experience with this disease, and therefore could make the decision, and also it was in his best interest not to have the chemotherapy given what the expert medical evidence was being said about that. That said, one thing the courts don't talk about, but I do think factors into their decision-making, is the likelihood of success. In other words, it was not likely in that Newfoundland decision that the chemotherapy was going to have a wonderful and life-changing effect for this young boy, and tragically he was going to die. You could extend his life for a little bit, but you would be putting him under the burdens not only of chemotherapy, but having betrayed, in his eyes, his religious faith. Where you've got a therapy that is much more likely to be successful, and so courts will balance these things off, then I think that they would be less prepared to be swayed by the prospect of administering this treatment against active resistance. And that, in fact, was the case in AC. I don't know if she actually actively resisted when she received the blood transfusion, but she was given a blood transfusion. Yeah, so they take into account likelihood of success too.